going to hear next about legal issues in the workplace and knowing your rights. And I would like to introduce Debra Wolf, who is a supervising attorney at New York Legal Assistance Group. Please welcome Debra.
Hi, good morning. So my name is Debra, and I'm here with my colleague Domna, and we're two attorneys who provide free legal work for people with cancer. That's all we do. And Domna's going to talk a little bit more about our services at the end, because we're here to talk about employment law, but we do a lot more than that. So we're going to be talking about the workplace rights, and the three most important questions I get, which are, do I have to tell my employer that I have cancer? What if I need a reasonable accommodation? And what if I need to take time off? So these are the applicable laws in New York. New York is an at-will state, which means that we can be hired or fired at will. Our boss can fire us because they don't like certain things about us. They don't like the way that we work. They just can't fire us for discriminatory reasons such as race or sex or age or the fact that we have cancer or another disability. And then I'll talk about the three laws in New York, the Americans with Disabilities Act, which is actually a federal law, so it applies to all 50 states, Family Medical Leave Act, and then our New York State disability laws. So starting with the ADA, this is a federal law, so it applies to all 50 states for employers with 15 or more employees, and it prohibits discrimination based on disability and provides that employers have to give reasonable accommodations. So who is disabled under the ADA? This has been a very evolving process, because there were many years where the biggest issues were not, did this employer discriminate, but rather, is this person a covered person under the law? But the law was changed in 2008 to make it a far more inclusive law, so that a person has a disability if they have a physical or mental impairment that limits a major life activity. That could be sleeping, working, hearing, walking. But now the law was amended so that it includes impairments that are episodic, such as, let's say, MS, or in remission. So somebody who's a cancer survivor and in remission is still covered under this law because they still suffer from things like fatigue and neuropathy and other things that might impact their ability to work. And then without regard to mitigating measures. So for example, if somebody is hearing impaired but wears a hearing aid, they're still covered under the law now. In the old days, that might not have been true. I just want to point out that New York has very strong anti-discrimination laws, both city laws and state laws. If you're not in New York, make sure you understand your state law. So for example, our law covers people with 4 or more employees and gives the same protections as the Americans with Disabilities Act. So disclosure, these are the most frequent questions that I hear. Does an employer have a right to ask me about information during a job interview? I talk to people all the time who, once they're diagnosed, aren't sure whether or not they have to tell their employer if they are working. So I'm going to go through this a little bit on disclosure. The ADA has 3 separate employment periods with very different disclosure rules. First is pre-employment. You're applying for a job. What do you have to tell your prospective employer? Basically, no disability-related questions are allowed. Your employer can ask you things like, are you able to carry 10 pounds? Are you able to lift this? Or are you able to walk a certain amount, depending on what the job duties are? But they aren't allowed to ask any medical questions. I see you have a limp. What's a limp? What's, medically wrong with you? I see you have a gap in your resume. Did you have a health issue? Totally prohibited questions during the pre-employment inquiries. But they can specifically ask about how you would perform certain tasks. Some employers may give a conditional job offer, which is basically offering the job subject to medical testing. Most employers don't do this, but some do. And some of these are jobs such as, let's say, flight attendants that have a element of public safety. During this period, not only can an employer ask disability-related questions, they can require medical exams, and they can be very, they can ask anything. They can ask you to take blood tests. They can ask for things that may not be related to the job at all. They could ask, for example, for HIV tests. Very broad rights that the employer has if there's a conditional job offer. But they can't reject a job offer based on learning that you have a health issue unless it's determined that you can't do the essential functions of the job. Some people will call me and say, I don't want to tell, I'd rather, I'm not going to fill out this questionnaire correctly. My advice is always respond correctly, because you're protected if you disclose and can show that you are able to do the essential functions of the job. You're not protected if you don't respond accurately. If you don't respond accurately and the employer finds out, they do have the right to renege the job offer. So much more protected when you disclose that you have a disability. And then finally, once you're working on the job, and basically any inquiry has to be job related and consistent with business necessity. So again, employers have more rights when somebody has a job that involves public safety. They may want to intermittently make sure that somebody's going to be able to do the essential functions of the job and has the physical stamina or ability to do that job. Other than that, it's really if the employee would pose a direct threat due to a medical condition, that's going to be a tough burden for an employer. So for most people who work in office jobs, things of that nature, on-the-job inquiries are not going to happen that often. I just want to point out that drug testing is a whole different thing. These laws don't apply to employee drug testing, and employers do have the right to drug testing it based on whatever policy they have, and they're not governed by these laws. Biggest thing about these laws is that it allows the employee to ask for reasonable accommodations. You have a job, you need to modify something about your job. This could be anything from changing your work hours to an ergonomic chair to taking more breaks. Had a client once where there was a policy that they didn't allow food at the desk, and she needed to have crackers to combat nausea. That was her modification. It has to be an interactive process. An employer can't say no. They can say, you know what, this might not work for us, but let's talk about what's going to work. I've helped people set up working from home. As long as you can do the essential functions of your job, working from home might be an option for somebody who's a writer, somebody who's a graphic artist. I was working recently with somebody who works in development, and her job is telephone calls. She can do that from home. So there's no set list of accommodations. It really is on a case-by-case basis. And I urge people, when they need accommodations, to think about what's going to help them do their job better. Here's some other accommodations, such as flexible working hours. It can be something physical like getting access to a desk, or it can be something like changing work hours or modifying work hours. I always suggest somebody, if they have human resources, ask for an accommodation through HR. People go to their supervisors and say, I need to get an accommodation. I need to take a longer lunch break. And supervisors inevitably say, oh, we don't do that here. That's because they don't understand what their rights, what their responsibilities are, and what employees' rights are. That's what HR is there for. So really, if there is human resources, include a letter from your doctor saying, I'm the treating physician for so-and-so who has breast cancer, and this accommodation is medically necessary for these reasons. It doesn't give your employer access to medical records. A letter from your doctor is sufficient. And again, I mentioned there's the interactive process where an employer has to say, let's talk about what's going to work. And I just wanted to refer everybody to this website for anybody who's working. Terrific website that talks about typical accommodations, makes suggestions for accommodations that are disability specific, and a really good resource for anybody that's working. If somebody does request an accommodation with a medical letter, it doesn't go into their employee file. It goes into a separate medical file. So if you have a supervisor that wants to look in your employee file, let's say for other evaluations, there should not be any medical information in there. It has to be kept separate, and the information has to be kept confidential. Discrimination does occur. These laws are here to protect us, but we do have employers that don't do what they're supposed to do, although I will say the majority of people that I work with have pretty good work experiences, but we do have those cases from time to time where employers either refuse to accommodate or there is discrimination based on a cancer diagnosis. Talk to somebody in HR again, they can be very helpful. There's a lot of different organizations with which you can file complaints, the EEOC, the City Human Rights Department, the State Human Rights Commission, but always talk to an attorney because deadlines are very strict and these laws are complicated if you think that there is discrimination happening. Another law that I want to talk about is FMLA, and this applies to employers with 50 or more employees, and you have to have worked at your job for a year. If you meet these criteria, then you are allowed for up to 12 weeks of job-protected leave, which means that if you have to take time off for surgery, if you have to take time off for treatment, you have a job to go back to. Your health insurance and benefits must continue during that time. And so with the ADA and accommodations, the obligation is on the employee to ask for this. And in fact, employers are prohibited, again, from going to their employee and saying, you look like you're not feeling well, do you need an accommodation? That's prohibited. The employee has to ask. With FMLA, if somebody mentions that they're going to be taking medical time off, the employer has to advise them of their rights under FMLA. One of the nice things about FMLA is it can be used for intermittent leave. You can take a chunk of time, 12 weeks, let's say for surgery, or let's say you have chemo every other week on Fridays. You can set up your FMLA for intermittent leave every other Friday, or let's say you have chemo on Thursday, every other Thursday plus Friday because you need a day to recuperate, and you're protected. You're protected from a supervisor saying you're taking too much time off. If you take off another day, you're gonna, you could be fired. It's a law there that's, again, it's for larger employers, but, definitely worthwhile if you're missing any work due to health reasons to think about setting up intermittent FMLA. Some common questions: do I have to disclose my health to qualify for FMLA? Most employers actually have an application, and your doctor has to sign a certification that you have a serious illness. FMLA can also be taken for caregivers as long as it's a family member. You can take FMLA to care for a spouse, a parent, or a child. ADA only protects the employee. FMLA protects immediate family as well. For people that don't qualify for FMLA, let's say they work for a smaller company, time off, it can also be requested as an accommodation under the Americans with Disabilities Act. And I've read cases where even up to a year time off can be a protected accommodation, case by case basis. If you work for a large company, a large national company, they're going to be able to bear the burden more of somebody taking time off as opposed to a small employer. So everything really, you have to look at the circumstances. And if FMLA leave is unpaid, how do I pay my bills? You can use accrued sick time, you can use accrued vacation time, or you can use short-term disability. There's only 5 states that have mandated short-term disability, and New York is one of them. So everybody that works in New York has a right to short-term disability. It's for 26 weeks. That's the good news. The not so good news is that the disability is capped right now at $170 a week. So not really a livable wage in New York or any other state, but at least it's something coming in during this period of disability. So here's, I guess, a question that was added. So an employer has a right to ask for medical information about me during a job interview. I think I've already answered that, but well, 100%, excellent. So what I'm going to do is, do I have to tell my employer or prospective employer about my health status at any time? What do you think? Oh, it even tells me here how many responses there are. So the answer is 17% say yes, 83% say no. Remember that we talked about conditional job offers. At that point, you would have to tell your employer about your health status. Not during the pre-employment job interview, but if you get a conditional job offer. And also some circumstances while you're on the job, depending on, what kind of work you do and any elements of public safety. Is my confidentiality protected if I tell my employer my health status? While we're waiting for responses, you are not protected if you tell a coworker. If you have a friend at work and you say, you know what, I just want to, I like you, I trust you, I want to tell you about what I'm going through, there's nothing that prevents that coworker from telling 50 other coworkers. The choice of who you tell is so personal and who you want to know is so personal that I just urge people to think about who they talk to. Some people want everybody to know, and that's totally cool and fine, but if you want to really make the decision about who knows, be careful who you talk to, because just talking to a coworker, even a supervisor, it's not protected. You're only protected when you, let's say, go to HR and ask for an accommodation, submit a medical letter, but otherwise the law really doesn't protect you. So, can I be fired if I disclose my health status? I'm going to just move forward because I know that we have some time concerns. Remember, the most important thing with the ADA is you have to be able to do the essential functions of your job. So if your disability impacts your ability to do your job, there are some circumstances where an employer can say this isn't going to work out. If it's something temporary, though, remember, you can use either FMLA or accommodations to get through that period to keep your job. So the only time you can be fired is if you disclose, but you're not able to do your job, you're not eligible for FMLA or protected leave. Do I have to disclose my health status to qualify for FMLA leave? And as I said, most employers actually do have a form. It's with an accommodation. I suggest that you put together a letter and ask for an accommodation. With FMLA, generally your employer will have a form. But you most definitely do have to show that you have a serious medical condition and are entitled to FMLA leave. So I'm going to ask Domna to come up now because we have a special grant. We're funded to provide free legal services to women with breast cancer. And we've talked a little bit about employment, but she's just going to talk for a quick minute about the other type of work that we do.
So first off, I'm so excited to hear the other speakers and just hearing all the different areas, nutrition, genetic counseling, and just how much we're seeing with breast cancer and all of these different areas coming together. So, as many of you are aware, cancer impacts all factors of your life. Debra talked about employment, but really it can expand to housing, not being able to pay your rent because maybe you took time off and aren't able to sustain your financial income, to dealing with immigration, public benefits, health insurance, Medicaid, Medicare, Social Security, advanced planning, the list can kind of go on and on. So oftentimes we think of law and lawyers as those who are going to be in court or filing lawsuits. But really, I think the best way to think of it is that the law is meant to be there to protect you. And knowing the law and understanding the law is really about being able to enforce protections and rights that you currently have. So when you're also dealing with cancer, not only is it about sort of trying to prevent having to go to court or dealing with lawyers, it's about reducing your stress, being able to maintain, access to all of these really wonderful health benefits that we're seeing with all the research and science going out. So in an attempt to try to reach more breast cancer patients, what we've been working on are having legal clinics either in hospital settings, which is where most patients are, but also with a new project for metastatic breast cancer patients. So as we're seeing with a lot of the health benefits, individuals with cancer are living much longer, but at the same time, you're dealing now with a lot of these financial and social stresses that might have at one point been seen at the end of life or just for a short period of time. So what I just have up here is a little bit about the project that we have. And while we have on-site clinics at many hospitals in New York, this project is really geared to anyone in New York who has breast cancer or metastatic breast cancer. So that's really just what I wanted to talk about briefly. And with that being said, it's so wonderful to have everyone here. And thank you.